morning, everyone, and welcome to your North Carolina Court of Appeals. I'm Judge Lucy Inman, and presiding with me today on my right are Judge Toby Hampson, and on my left, Judge Jefferson Griffin. We have one case on the calendar for oral argument this morning, and that's the State of North Carolina versus Cheeto Charles, file number 21-792 out of Cumberland County. And counsel, are you ready to proceed? Very well. We will start. We will hear from the appellant first. And we have a new and improved clock system in this courtroom, at least new from the last time I was here. And can counsel see the time as clearly as I can?
Yes, Your Honor.
That's great. Okay. Very well. Do you wish to reserve time for rebuttal?
Yes, Your Honor. 5 minutes, please.
5 minutes. Thank you very much. You can proceed now.
Thank you. Good morning, Your Honors. May it please the court. My name is Danielle Blass, and I represent Cheeto Charles, the defendant appellant in this matter. Your Honors, the state charged my client with second-degree arson of a house, and Mr. Charles does not contest this conviction. But the state also charged my client with felony cruelty to animals, even though there was no evidence that he knew that there was a dog in the house. And he was convicted of cruelty to animals only because the trial court unilaterally transformed the cruelty to animals statute from a specific intent crime into a felony murder of animals crime. Further, the indictment that brought this case before the trial court was invalid. Today, I would like to walk through each of the 3 arguments raised in our brief in that order. Your Honors, first, the trial court erred in denying Mr. Charles's motion to dismiss for insufficiency of the evidence of cruelty to animals. North Carolina General Statute 14360 says that if any person shall maliciously kill any animal, they're guilty of cruelty to animals, and if they intentionally kill any animals, they're guilty of misdemeanor cruelty to animals. And the statute defines the terms. So maliciously is defined in 14360 as intentionally and with malice or bad motive, and intentionally is further defined as knowingly and without justifiable excuse. The state has conceded on page 15 of its brief that there is no direct evidence that Mr. Charles acted intentionally or maliciously because there was no direct evidence of knowledge of the dog. But what is critical here is that there is also no circumstantial evidence of knowledge. There is merely speculation and conjecture. We see from Yarborough and Fryew what sufficient circumstantial evidence of knowledge can look like. And so the examples are, in Yarborough, that's probably the most similar case we have today. The defendant beat up a couple, and while they were in the hospital being treated for their injuries, he burned down their house. There was a dog inside. He was charged with the exact same 2 crimes as Mr. Charles. This court said that to prove intent, the state had to prove that the defendant knew the dog was in the house. And this court said that the following was sufficient circumstantial evidence of knowledge. The defendant had been to the house 7 to 9 times, and on each of those occasions, the dog had growled at him when he entered. The dog was in the house when the defendant assaulted the owners earlier that day in the home. The fire was started in the living room in the middle of the house, so the court knew that the defendant had to enter the home in order to start the fire, and the owner had left the dog free to wander the house, but when they returned after the fire, the dog was locked in the bathroom, indicating that the defendant had actually moved the dog. Similarly, in Fryew, we have a case where a sex offender entered a church with a nursery to meet with a pastor. He was charged with being a sex offender unlawfully on premises. This court again said that knowledge, in this case of the nursery, was required to prove intent. And the following was considered substantial circumstantial evidence of knowledge in that case. There were signs around the church that said nursery. The entrance that he walked into to meet with the pastor was the same entrance as the nursery. There was a sign on the door he entered that said nursery. And there was, the church also advertised in the community and online for their nursery. So I want to emphasize today that in contrast to Yarborough and Fryew, there is no circumstantial evidence of knowledge in this case.
So the facts of this case are basically that Mr. Perry and Mr. Charles had some kind of relationship. I gather there was evidence that Mr. Charles had in fact been present in Mr. Perry's residence and visited. And one of the things the state argues here is that you're sort of kind of going outside the bounds of a motion to dismiss review and drawing the inferences in the defendant's favor. And obviously, motion to dismiss, the tie generally goes to the state if there's any, if it's a close call. So why isn't the state entitled to an inference at the motion to dismiss stage that given the relationship, given the friendship, given the fact that Mr. Perry was in a relationship with Mr. Charles's sister, I think it was.
Right.
Why is it not an inference to be drawn in favor of the state that Mr. Charles would have known that there was, in fact, this 4-month-old puppy in the house?
Your Honor, I believe all inferences are being drawn in favor of the state. And so what we have here is just two people knew each other. That is speculation and conjecture. We don't have circumstantial evidence such as that if the state had produced evidence that he had been to the house in the month prior to the fire, right, when the dog came to live there, maybe that could be circumstantial evidence, but we don't have that.
I mean, it seems like, reading through some of the record and briefs, it looks like there was testimony back and forth. Like, it's not all clear, right? Aren't you asking us to reweigh the evidence here? I mean, isn't that, that's what you're asking us to do when, we're looking at what happened at the trial court, and they had the ability to sit there and judge these folks and judge their credibility and look at them and see them in the eye. And I think, isn't that something we should take into account here?
We should absolutely take that into account, Your Honor, except that the state's evidence, even in the light most favorable to the state and even, drawing all inferences in their favor, there was no evidence of circumstantial knowledge. So when we look at these other cases, there was no beware of dog sign. There was no evidence that he had ever been to the house in the month prior. So all of the evidence before the court was to the effect of that even in the light most favorable to the state, was that Mr. Perry had gotten the dog 1 month prior to the fire, that Mr. Charles had been to the house 5 to 7 times over a 6 to 12 month period. There was no indication of whether he had been there before, and we can see that in the transcript on page 155, no indication he'd been there during the 1 month. And when you break it down into the different witnesses' testimony, Mr. Perry said 5 times, that's on 155. He didn't say what time window that was in other than the 6 to 12 month period. Mr. Charles said at least 7 times, but spent the night 1 or 2 times. That's on page 275. And the neighbor who testified from across the street said 5 to 10 times. That's on page 25 of the transcript. And we know that about 1 month before the fire, the relationship between the two men became not good. We know that about 1 month before the fire, the two men talked 3 to 4 times 1 month prior. And when you look again into the transcript, the question to Mr. Perry is, how far before the fire did you all have these 3 to 4 negative conversations? And he answers 1 month prior. So this is not circumstantial evidence of knowledge. This is not drawing inferences in favor of the defense, which is not allowable. There would have had to be more, maybe a beware of dog sign. Maybe the dog had growled at him at some point. None of that was in evidence. We have no evidence that the dog moved from the location it was confined in the kitchen, as in some of these other cases. No evidence that the defendant even entered the home on the day of the fire, right? The state's evidence was that the fire was set on the porch outside the front of the house and that defendant didn't enter. And we know from the state's evidence that that dog was confined, so it's not like it could have run to the front door growling when the defendant came to the front of the house. And I think it's fair that in the absence of this circumstantial evidence, we can also ask questions like, why didn't the state ask its own witnesses, Macumba Charles and Marcus Perry, if they had ever told my client about the dog, or if my client had ever been to the house in the last month, or if he had ever seen them with the dog? Those questions weren't asked, and I think we can ask why, right? And I think we can ask, why did the state ask for a transferred intent instruction? And the answer to those questions is because there was no evidence that Mr. Charles knew that there was a dog in the house. Your Honors, the second issue we raised in our brief is that the trial court erred in instructing the jury that cruelty to animals could be proven by transferred intent, such that the state only had to prove that the defendant intentionally and maliciously started the fire, instead of requiring that the state to prove that the defendant intentionally and maliciously killed the animal. Here is what the trial court instructed the jury with regard to the first two elements. For you to find the defendant guilty of cruelty to animals, the state had to prove three things beyond a reasonable doubt. First, that the defendant caused to be killed a 4-month-old puppy in a house fire. Second, that the defendant acted intentionally, that is, knowingly starting the house fire. It's important to start by looking at the statute. So I want to emphasize that the statute sets out the mens rea. It says you're guilty of felony cruelty to animals if you intentionally and maliciously kill any animal, and it does not say you can transfer intent. Second, the general rule in North Carolina is that an intention to cause one type of harm cannot serve as a substitute for a requirement of an intention as to a different type of harm. The doctrine of transferred intent is a really narrow exception to that general rule, but the transferred intent exception typically derives from a statutory definition for a specific crime and involves a transfer from person to person, and we don't have any of that here. So when the state asked this court to treat cruelty to animals like felony murder, they're asking the court to legislate from the bench and create a felony killing of animals law. We see the conversation about this in the transcript on 297 and 308 to 310. If the legislature wanted to create a crime for harming animals in the commission of another felony and only requiring mens rea for the underlying felony, they could have done so, but they did not.
So, one of the things I think we'll hear from your colleague from the state is that cruelty to animals is not a specific intent crime. What authority do you point to say that, yes, in fact, it is a specific intent crime?
Your Honor, first is the actual wording of the statute. So when we look at that actual wording, it says defendant intended to kill the animal, or fill in the blank for how that defendant is charged, right? So if they were charged with torturing an animal, with injuring an animal, and they are charged as such, then that is the intent that they have to prove. In this case, Mr. Charles, per the statute, was charged with killing, and so just by the plain language of how it's worded, that indicates to us a specific intent. And further, I think that the cases in Yarborough and Wilson back that up. So Yarborough was the case we talked about.
Yarborough is unpublished, right?
Yes, Your Honor, and a lot of these cases are, but Yarborough is such similar fact pattern that I do believe it's important for the court to look at. But the question in Yarborough wasn't
Is there any, sorry to interrupt you.
Not at all.
Is there any published case law or other authority holding that felony cruelty to animals is a specific intent crime?
No, Your Honor.
So we're on a blank slate here. Is that correct?
That's correct, Your Honor. And I think, you'll hear throughout the argument, and Your Honor has read in the brief as well, that it's our contention that this is a specific intent crime. But I think it's also important to point out that whether or not the court decides that this is a specific intent crime, even in general intent crimes, knowledge is required and intent to at least harm the animal. So even if this court disagrees about specific intent, even general intent would require knowledge of the dog.
If I can just ask you, and I know you've stated your disagreement with the theory of transferred intent as it might have to do with, say, if there were a child in the home, right? But pets are not rare in homes, right?
Right.
It's not like a rarity that you would have a dog in somebody's house. But if I'm understanding your argument, it is simply in comparison to Yarborough, which is an unpublished case, because in that case, in that unpublished decision, this court, pointed out some circumstantial evidence of knowledge, that sets a bar for having to have some circumstantial evidence that this defendant, Mr. Charles, was actually at the house sometime after the dog was there. Some evidence that the defendant's sister had talked to him about the dog, or that Mr. Perry had talked to him about the dog. And you're simply saying it's speculation to say that, people have dogs in their homes, but you didn't know there was a dog here, that's enough. And that is your argument. But you are asking us to make new law. Would you agree?
Your Honor, I don't think that you have to make new law for this for the case to go in favor of the defendant. I think that whether, as I mentioned earlier, Your Honor, I think whether or not it's a general intent crime, it is not new law to say that the defendant would have needed to have knowledge of the dog. And I want to sort of reiterate that in cases like Yarborough, the court did not ask, and I do understand it's unpublished, but the court could have asked, did the defendant intentionally start a fire and allow a transfer there? But it didn't. They asked whether there was evidence of knowledge to support a finding that he intended to kill the dog. And in Wilson, we see another case. The defendant drove drunk with a new pit bull tied to the back of her car, seriously injuring it. She blew a .09. She said she didn't know that the dog was tied to the back of her car, and the only question before the court was whether she had intent to harm the dog. The question was never, did she intend to drive drunk? And the court also said that she was not entitled to a misdemeanor instruction because if she didn't know there was a dog there, she was not guilty of both the misdemeanor and the felony. If she knew it was there, then she was guilty of the felony. So we see that the court is not transferring intent in any of these crimes where, any of these alleged crimes where, there's an arson or there's a drunk driving. I think it's also important to point out that when you look at second-degree arson and cruelty to animals, the gravamen is different. So the cruelty to animals statute exists to punish people who are intentionally maiming animals. It's there to protect animals because they're vulnerable. They can't protect themselves. In contrast, second-degree arson is there to protect real and personal property, not a vulnerable group like animals.
Do you agree or disagree that your client acted maliciously in setting the fire?
Your Honor, I think that the state showed that there was the necessary mens rea for the arson, and that's why he was convicted, and we do not contest the second-degree arson conviction. And he did serve the full time for that.
But in terms of whether he acted maliciously for purposes of the cruelty to animals statute?
Yes, Your Honor. Not for the cruelty to animals statute, I'm sorry, for the arson statute,
So
yes.
what's the difference? Is it again that even in malicious under the cruelty to animals statute, that also carries with it a specific intent?
Yes, but Your Honor, even if it doesn't, the malicious act still has to be towards the animal, knowing that the animal is there, right? Otherwise, you're in a situation, you don't see the state, Your Honor, charging, like for every mouse or that, burrows into a roof. When someone commits a second-degree arson, we don't hear of them being charged with cruelty to animals because, yeah, mice do burrow into places, to homes, but they're not charged with maliciously killing them when they start
But aren't
fire.
animals treated, and, people love their pets, and you describe them as, vulnerable, but aren't animals treated as property under the law? And like the distinction that you just draw about a mouse, well, I don't know many homeowners that are going to claim ownership of the mice in their house. They would like them to be gone, whereas their pets, they give them names, they own them. So isn't that different?
Your Honor, it is, and that's a good point, Your Honor. But I think the important point that I want to make about property is that, yes, pets are technically property, Your Honor, but they're a totally different type of property. So when we talk about the real property and personal property that is covered by second-degree arson, the General Assembly has said you can harm or destroy your own property, your own real estate, your own personal items, but you can't harm or kill your own animal. And so they are different types of properties. And I think that leads us to the one type of non-statutory transferred intent that we saw under Fletcher, that is discharging a firearm into an occupied dwelling. And what we see there, Your Honors, is that the state was allowed to use the theory of transferred intent to prove the crime of discharging a firearm into an occupied dwelling. In Fletcher, the defendant intended to shoot his victim. He did shoot her as she was running down the street, hit her in the back. She fell and somehow was able to get up and keep running into an occupied home. And he shot at her as she was escaping into the occupied home, and his bullet missed her and hit the occupied home. So the idea with transferred intent is that if you shoot a person, you don't get the benefit of your bad aim. In contrast, Mr. Charles was not aiming at a person. We don't see transferred intent from protection of one type of property to protection of another type of property. So to Your Honor's point, even if real property is property and a dog is technically property, we're not seeing transferred intent in that context throughout the law in North Carolina. Just for the protection of one person, so in the Fletcher example, that would be from the intended victim who was shot to the occupant of the home, right? The transfer is from protecting one person to protecting another person. And to the extent that intent can be transferred to humans, it cannot be transferred to animals. We do treat animal deaths differently. It's the policy of the General Assembly. They have said we value humans above animals, above property. Humans over animals we see because there's a felony murder statute for people, not for dogs or other animals, because you don't get a life sentence for killing a dog, and because we see animals over property because of what we discussed earlier, that you cannot harm your own animal, but you can harm your own physical, personal, or real property. So you can destroy your own property if you want to. Your Honor, the third issue argued in our brief is that the trial court lacks subject matter jurisdiction because the indictment was fatally defective in that it failed to allege 2 out of 3 essential elements of the crime of cruelty to animals. We all know that to pass constitutional muster, an indictment must allege lucidly and accurately all of the essential elements of the crime charged. And as we discussed, the elements of felony cruelty to animals are kill any animal intentionally and maliciously. What is most critical here is that the indictment did not allege that the killing was done maliciously. This court has invalidated indictments for failure to allege essential elements. So one example is Bullock. In that case, that was a first-degree murder case. An ex-husband shot his wife 4 times in front of their children. This was a very high-stakes case, and the state failed to allege malice aforethought in the indictment, and this court arrested judgment. So we see this court be appropriately rigid in requiring essential elements even when the stakes of a case are quite high.
So in looking at an indictment like this, where the second-degree arson is included on the same page as the cruelty to animals charge, so how are we as an appellate court to review this? Are we to review it sort of as a whole, in sort of in toto, where there is an allegation of malicious actions in terms of, on this page, it relates to the arson. Are we to look at that, or to look at it as a whole, or are we to look at it as individual counts?
Absolutely not, Your Honor. We're to look at it as individual counts. I've never seen a case where this court allows the state to borrow essential elements from one count and use it on another, and I've certainly never seen a case where a mens rea element is allowed to be borrowed from another count.
And then in the cruelty to animals piece in particular, it does allege that it's felonious. It cites the statute. How is that not enough to put your client on notice of exactly what he was being charged with?
Your Honor, the word felonious is not enough, if that is what Your Honor might be asking. There are several crimes that shift from a misdemeanor to a felony when an element is added, where this court has said that the allegation of the additional element that makes it a felony is required. So we know feloniously is not enough. Examples that this court has looked at are making and uttering forged checks. That transfers from misdemeanor to felony at $2,000, and that additional element must be alleged. It's not enough to say feloniously. Same as with larceny, the threshold is $1,000, and another example is carrying a concealed gun, where it shifts from a misdemeanor to a felony once it's 1 second charge. And in all of those cases, this court has said that it must be alleged. So that would indicate that feloniously is not enough.
Can you point to anything that shows that it prejudiced his case, or he wasn't able to prepare because of that?
Your Honor,
of the alleged admission?
Your Honor, I think that this court has been clear that the essential elements are required constitutionally to give notice. That's been decided time and again. And in this case, it is also 2 out of 3 elements for the felony. That's a lot. And so I think it's very fair to say that no proper notice is given when 2 out of 3 essential elements are missing, or even 1.
Okay. Ms. Blash, you're getting into your rebuttal time, and I just wanted to point that out to you.
Thank you. I will allow the state to go next. Thank you.
Thank you very much.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Haley Cooper. I'm an Assistant Attorney General here on behalf of the North Carolina Department of Justice and representing the state in this matter. I don't believe it's lost on Your Honors that there was an innocent puppy that died in the fire that day, that the defendant did, in fact, maliciously set a fire in which a dog died. And that's the only conviction that this defendant is challenging. All 3 of the arguments the state argues is without merit, beginning with the sufficiency of the evidence. Judge Hampson, you're correct in saying all of these facts should be viewed in the light most favorable to the state. All of the contradictions should be resolved in the favor of the state. All reasonable inferences, whether there's 1, 2, 3, all reasonable inferences should be given to the state in the consideration of sufficiency of the evidence. And you're to consider all of the evidence. The defendant argues in such a way that would ask Your Honors to consider inferences of innocence, asked to weigh the evidence. I believe, Judge Griffin, you acknowledged that, as well as credibility of the evidence. All of these things are things that Your Honors are not supposed to consider.
Ms. Cooper, can you just, I just want to ask you to sort of list for us, and as I understood Ms. Blass to argue, she was saying there's not any evidence to weigh. I understood her to say there's not any evidence from which to draw an inference that the defendant knew there was a dog in the house, because there was no evidence that he'd been to the house within the time period that Mr. Perry adopted the dog. There was no evidence that he had spoken with his sister and learned from her about the dog. There was no evidence that he'd spoken with Mr. Perry and learned about the dog. Beyond the circumstantial evidence that the defendant's sister lived with Mr. Perry during the time that he had this dog, is there other evidence that you're pointing to from which every inference needs to be construed in favor of the state?
Absolutely, Judge. The record reflects that the victim, Marcus Perry, and the defendant spent a, quote, good amount of time together. They were quite often together. He even spent the night at the victim's home, was there multiple times. He had access to the entire home whenever he was there.
Any evidence of those things happening at around the time that Mr. Perry adopted the dog or after?
It's a generalization of the time in which they knew each other. Your Honor's right that there are no specific facts to that period of time. However, the generalizations were made. It wasn't, they were together a good amount up until the month before the fire. The generalization covers that entire time span, and a reasonable inference could be made from that to lead a juror to believe that he did in fact have evidence of the puppy being there. Further, the defendant himself says, quote, he is always together with his sister. So as much time as the sister was around the victim, Mr. Perry in this case, so was he. He had the opportunity on the stand to say something otherwise. He made that broad generalization as well at that point.
When you say he had the opportunity on the stand to say otherwise, who you're talking about?
The defendant. The defendant, in fact, said that.
So is it your position that it wasn't the state's burden to produce evidence that this defendant had knowledge, but that it was the defendant's burden to offer evidence that he didn't have knowledge?
Absolutely not, Judge. Just to take that into consideration, all of the evidence should be taken into consideration, including the defendant's testimony. The defendant's sister was dating the victim, Mr. Perry, in this matter, lived with him, she said, for months, but 2 weeks, I believe, is what the victim said. She had continuously been living there. And with the defendant saying that he is always with his sister, as much time as she is around the victim in this matter, he was, I think a reasonable juror could believe that he, in fact, did have knowledge of this dog. In addition to that, Judge.
But that's really the sort of the tension here, right? And that's, you know, is what is an inference that can be logically drawn from the evidence, and what is speculation, right? And so how are we as an appellate court to draw that line between, you know, as a legal matter, not as a factual matter, between what constitutes an inference and what constitutes pure speculation?
Sure. So it's evidence that a reasonable mind may accept as adequate to support a conclusion, tending to prove a fact or reasonably conducive to its conclusion as a fairly logical and legitimate deduction. And if you think about it from the point of view of a juror, if I'm going over to someone's house multiple times, my sister's living there, I'm always with my sister. The puppy's been in the home with her for the month or 2 weeks that she's been there, and I'm always with her. A reasonable juror could be led, or it would be appropriate for a juror to reasonably believe from those facts and conclude that he did in fact have knowledge of that. In addition to that, the neighbor in this case, who kind of was like a watchdog for the neighborhood is how it was portrayed in this case, said that, you know, he was always over there at that house. He always saw his van. So when he pulled into the yard that day, it didn't alarm him at all because he's over there so often. Although he knew the victim was away working that day, this defendant being in the yard was not of concern to him because he's over there so often that you know, it was commonplace for him to be over there. Judge, we would say in addition to that, the courts have also implemented common knowledge in making these determinations. And as Judge Inman said, lots of people keep their animals inside of their home. In addition to that, when a puppy is in a home, we all know common knowledge. The vast majority of them make themselves known by barking or playfulness. So it wouldn't be uncommon for a person to be inside of a home for a puppy to even let himself be known, or if you're even on the porch to come to the door and bark and chirp. That's just the nature of puppies.
You know, unlike or like Yarborough, maybe was there any evidence that as to this puppy's demeanor, its behavior, whether it barked, it growled, it did anything like that?
Judge, the only evidence from the transcript was that he was a healthy puppy, acting normally as a puppy would. No specifics beyond that, but that would be just a reasonable deduction. We would argue for common knowledge. As in Fletcher, they said that the defendant had knowledge of the home being occupied because homes are often occupied at night when people are sleeping. So that was enough for knowledge in that particular case. And on the same point, Judge, we would argue that the way that the legislature has set forth intent in this particular statute says intentionally is an act committed knowingly and without justifiable excuse. It says an act committed knowingly. So, Judge, we would say that just in the plain reading of that, it's knowingly committing that act, doing that act. Therefore, knowing of the animal in the plain reading of the statute is not required. We would argue that it's knowingly doing the act, not accidentally setting the fire that killed the dog, knowingly doing the act. So either way that your honors find knowingly is defined under this statute, the state has met their burden in either situation. Clearly, we have enough evidence by the conviction that he did knowingly set that fire, right? And in addition to that, we do have substantial evidence, although it's our position that we didn't have to, that he did in fact have knowledge enough sufficient to go to the jury to determine whether or not it was proven beyond a reasonable doubt.
And that also feeds directly into the transferred intent argument, correct?
Yes, Judge.
That it's the state's position that if the defendant here were an utter stranger to Mr. Perry and had never been to his home and went and maliciously set a fire on his porch, that he would still be guilty of felony cruelty to animals because the fire killed a dog.
He knowingly, maliciously committed the act that then the malicious intent would transfer over to the property inside the home, the property in this case being the animal. Judge, and the transferred intent theory laid out by the defendant, it was a little bit hard for me to follow. So I would like to lay it out in the way that I best understand it. We've got the common law theory of transferred intent, where it goes based on common law, person to person. I intend to shoot this person, but I accidentally shoot the person beside them. Then we have transferred intent that's codified within our statutes with the felony murder rule, right? We've got these specific laid out felonies, including arson, that if in fact a human death results based on that, our legislature said that that's enough for first-degree murder. And then in addition to that, the court system and the case law has applied what they said was a common sense analysis in regards to transferred intent. And that's where we're talking about the Fletcher case as well as the Small case, and Byrd also speaks to this. In making that common sense application, the court said that they considered in the transfer from, and these three cases all involved an assault of some sort, transferring to a discharge of a firearm in an occupied property, two different types of crime, two different types of harm, but they applied that analysis saying, well, one, discharging a firearm into an occupied property is not a specific intent crime, so it makes sense that you could transfer it. The second is that the crimes were similar in type. When the legislator created these two crimes, their intent was to protect the people, protect persons with the assault, and then the discharge of firearm into occupied property, although it says property in the title, is in fact the purpose of it is to protect humans in an occupied property, right? So the legislature, the court determined it made sense to transfer because they're similar type crimes. Judge, in this particular case, we would argue that, similar to Fletcher, animal cruelty is not a specific intent crime. And how do we know that? Well, we look at the legislature and how they wrote it out. Typically, whenever a legislator wants to create a specific intent crime, they do what? They write they have the specific, or they have the intent to do something, right? You can possess marijuana, and that would be a general intent crime, as one of the cases reads. But within that same statute, the legislator says when you possess that marijuana with the intent to do something else, sell, deliver, then that is a completely different crime because you're possessing it, but then you are possessing that general intent with a specific purpose. And they lay that out in the statute. The animal cruelty statute is laid out in a similar way. We've got the cruelty to animals that falls under that, has no reference to intent to do anything. But then within the animal cruelty section of the statutes, we go to dog fighting. And dog fighting does in fact say with specific ownership of the dog or having the dog with the intent to use it for dog fighting. So it's clear that the legislator wanted to create a crime that was a specific intent crime, in that dog fighting, the possession of that dog, you had to have a specific intent to use it in dog fighting to be convicted under that crime. So if you go through a common sense analysis in regards to how the legislature intended, if they wanted it to be a specific intent crime, they would have told us that by their language. In addition to that, Judge, we would argue that the state,
What would it look like if they were going to write a specific intent crime for animal cruelty? What would that look like?
with specific intent to harm the animal, or specific intent to kill the animal, or specific intent to torture the animal, or with the intent, not even specific intent, with the intent to do whatever the act is. And that's not the way that the statute is written. It's written more in a general term. In addition to that, Judge, we would argue that the defendant says that because if your honors do in fact find, which we would argue that you wouldn't find, that knowledge of the dog is necessary, but assuming arguendo that you do in fact find that, the defense argues that because that knowledge is required, if you in fact find that, which we're asking that you don't, that because that knowledge is required, that it can't be a general intent crime, and that's just not correct. There are several circumstances in which there is a knowledge requirement, like in the Fletcher case, knowing that the property is occupied, but it is considered a general intent crime. In addition to that, we have driving while license revoked. You have to know that your license is revoked, but you don't have to do it with a specific intent. It's a general intent crime, but you do have to have that requisite knowledge. Another case, transporting intoxicating liquors, whenever that was against the law, the court also said that it's a general intent crime, but it does require a requisite knowledge. So just because there's a knowledge element to it, does not mean that it cannot be a general intent crime. The second part of the analysis in Fletcher, in this common sense analysis, is that it's a similar type and purpose. So as I believe Judge Inman, you said, animals are considered property under the law. However, the courts or the legislator provides it with additional protection and punishment for harming animals than they do a chair. They acknowledge that animals are sentient beings. They do deserve more protection than your chair that you sit in every day. You cannot maliciously harm your chair, but you can maliciously harm your dog. So we would ask that you would find that it's a similar type of purpose, that they are property, and just because they're a property plus in a certain way doesn't mean that they shouldn't get the same coverage as being a regular property, right? In fact, I would argue that it would get even more protection at that point. So we would ask that you would find that it's similar in type and purpose. In addition to that, there's some policy concerns I would say to consider in regards to this analysis. And again, these two factors were not, or these two considerations were not deemed factors of an analysis to use in every case. They just said that this is a common sense analysis, and these were the things that we considered in these particular cases of an application by the courts of transferred intent. The policy reasons, Judge, that you are, like the defendant said, in Fletcher, the defendant should not get the benefit of having bad aim. Well, this defendant should not have the benefit of the fire spreading to the entire home and killing the animal that's inside, as well as destroying other property. He shouldn't get the benefit of that, Judge. Also, the ownership of the animal, with the property plus, animals are some folks' most prized possessions. You know, it's the most valuable piece of property to many. There are many folks that probably be more upset about their dog or cat or whatever being injured in the home fire than they would, in fact, their home, because they can cover that with insurance but not replace their pet. So we would argue that for policy concerns in this analysis, it would make sense that if you're away at work and someone sets your house on fire and your dog is left inside, that dog should be protected under a transferred intent of maliciously setting fire to your home, thus maliciously killing your animal, because they intentionally and maliciously did the act that then in fact killed your most prized possession of property that's within your home.
When you talk about the sort of policy determination, right? I mean, typically that's for the General Assembly.
You're right.
And the General Assembly could define a level of arson, a higher level of arson based on the fact that it harmed an animal or a pet in the house, and they have not done that. So I'm failing to see how the policy argument flies here.
Well, I think you're right. It's typically the legislature, and we're not advocating for you to legislate from the bench in any way. It's just that could be a consideration in this common sense analysis that the courts have done in the past in determining whether or not it's appropriate to apply transferred intent to specific facts that come before them, because they're similar in type, because they're similar in outcomes, they're similar in that the transferred crime is a general intent crime. There's things outside of that Your Honors could possibly consider that would be a part of this common sense analysis. And I don't think that it's completely inappropriate to at least have that in mind, that it is property. However, it's some of the most prized property. So if they're going to be responsible for the chair that's inside the home when the home burns, then they should also be responsible for the animal that is killed inside because of the malicious intent transfer.
Well, and just to distinguish between the chair and the animal, of course, there's no statute for cruelty to chairs.
Of course.
For destroying chairs.
Right.
That would all be subsumed within the arson charge.
Sure.
Right? So this is different. Because this, and the only thing the defendant here is challenging is that additional charge.
That's correct, Judge. That's correct. And the malicious intent of the arson and the way that it's worded is consistent with the malicious intent of the animal cruelty in the state's position. The courts have said that you can define malice under animal cruelty in a variety of different ways. In Weber, it stated out several different ones. It says malice has many definitions. Hatred, ill will is the common layman term of what malice is, but it's not restricted to that. It could be a wrongful act intentionally done without just cause or excuse, which is what, in fact, arson is. Hardness of the heart, cruelty, recklessness of consequences. And in addition to that, the court said in Weber, malice may also be implied when an act is done so recklessly or wantonly as to manifest depravity of mind and disregard of ... life. And what they left out in the ... life was they were quoting a previous case that said human life. But in Weber, they put ... life, which would lead one to believe that this definition of animal cruelty wouldn't, or this particular malice definition would apply in a cruelty situation, because you are, in fact, depraving an animal of life. So we would say that that's appropriate into consideration as well, that the malice types are the same, in that the arson and the animal cruelty are consistently worded in such a way, based on what the evidence presents at trial, to which it would make sense to transfer that malicious intent over to the malicious intent of the animal cruelty. And Judge, you did state to the defendant that whether or not you're creating new law. And I think that that's arguable in this particular case because what the state's asking you to do is just to continue on what happened in Fletcher and Small and Byrd, is to do this common sense analysis in determining whether or not it is appropriate to transfer intent from one crime to the next, from one type of harm to another. I believe the defendant stated that the courts and the legislator have not allowed transferred intent from one type of harm to another type of harm, but that's not correct. That's what they're doing in Fletcher. That's what they're doing in Small. An assault is not the same type of harm as discharging a firearm into an occupied property. It is one type of harm to another type of harm. So the courts have allowed, and the legislature have allowed the person-to-person, right, that you, within the common law theory, that in the statute, that you have intent to do some sort of other crime, like arson, a different type of harm, but it in fact leads to death. So you've got harm of one type of crime leading to the harm of a person. And then the third type, which has been determined by case law, has applied type of harm to a different type of harm. And that's what we have in this case. And
But
so it's not...
The statute here doesn't say maliciously commit an act that results in.
Right.
It says maliciously torture, beat, kill, that. So, I mean, the maliciously seems to be clearly modifying those specific acts towards the animal.
Sure, yeah. And oftentimes in our cruelty cases, folks don't have the specific intent to do something to their animal. A lot of times it's that they're negligent in feeding and watering and providing shelter. They're not doing those inactions with the intent to have their dog starve to death. And that's not why they're doing those things. They don't have the specific intent for that to happen. They're just failing to do the things that then lead to that.
But that is an act,
Right.
knowing that there's an
Yeah,
animal
the
involved.
inaction
It's
is...
an action directly
Right.
towards the animal.
Exactly.
And that's misdemeanor.
It applies within the felony analysis as well. If you maliciously do that, then that would also apply.
If you, and yes, and there are cases where the court has found malice in, having a dog chained up and not feeding that dog for a long, long period of time. But again, the dog is known to the defendant.
Sure. But I don't think that that's required. Those are the easier cases. It's very straightforward in those circumstances. But I think that the way that the legislature worded this particular statute leaves it open to that it's knowingly doing the act or knowingly doing the inaction that then results in the harm. And moving on to if your honors are okay with it, moving on to the indictment. Judge, we acknowledge that the prosecutor left out malice, and that's typically looked very hard upon by the courts. The defendant argues Bullock, and we say that Bullock is pretty well on point in regards to they left out the word malice. But the difference between Bullock and our case is that in our case, the malice is described within the indictment language. In that particular case, it just said unlawfully, willfully, and feloniously did attempt to kill and murder. It has no specific indication as to how that occurred. Our indictment does, in fact, go beyond that. Unlawfully, willfully, and feloniously did kill an animal, a 4-month-old puppy, by using an accelerator to light the residence on fire with the dog inside the home. Those are facts from which malice could be inferred, and we would ask for you to do that. That gives him the notice of what the act is that we're saying was done in a malicious way. In addition to that, Bullock allowed the voluntary manslaughter, the lesser included, to stand in that case. You don't see the word intentional in their indictment. You see the word willful, and that's the word that we have in our indictment as well. And thus, we would say that in the very least, we have the misdemeanor animal cruelty that would stand in this case, because we do allege all of the elements crystal clear and based on case law, giving him notice of what he is being tried for. Judge, the state or the legislature as well as the courts are going away from these magic words, these archaic ways of making sure that you include these specific terms, that if you don't include a specific term, that they're going to strike the indictment down. We're getting away from that. The courts have said we're going more towards a plain, intelligible, explicit manner, no need for formal refinement. As long as it allows the defendant to have notice of what he's in fact being tried for, allow the courts to then enter judgment based on what's within that indictment, and also prevent him from double jeopardy. So if those things are met, then the indictment should not be required to have these specific terms. In fact, in this case, if we did in fact just allege malice, that would put the defendant on what we would argue is less notice of what we're talking about. The word malice doesn't give him the facts that by using an accelerator to light the residence on fire with a dog inside the home. That gives him a lot of notice as to what the state is going to argue in regards to this case. It gives him even more to prep with. Judge, in Russell, the court said, objections to indictments on mere form should not be considered unless there's reason to believe he's misled. There's no reason to believe that he's misled in this case. It's clear from the transcript that from the beginning, he knew exactly what he was charged with. He was represented by counsel. There was extensive talk as to the elements of the crime, including malice, which is alleged to be missing in here, as well as intent. There's no indication on the record that they were like, whoa, we didn't know that malice was a part of this consideration. There's no indication that he was misled in any way, that he was not apprised of the terms and the nature of the offense. And if he did have questions as to that, he could have filed a bill of particulars in regards to getting more information. And Judge, the court said that oftentimes defendants attempt to use the indictments, an error in the indictment, to reserve fire until they have their first chance at acquittal. And then going forward, proceeding on what they know is a deficiency in the indictment, then they raise before your honors. So they're, holding back that even though they have the notice, they know that they're being charged with felony animal cruelty. It's laid out in the language of the indictment. The statutes listed there, as well as felonious cruelty to animals, he knew that he was being charged with that and proceeding with that. I'm going over time.
Yeah, if you can just wrap it up.
Yes.
Thank you.
Thank you. So in regards to the combination of the two, I do want to address that if your honors will let me. Okay. In Nickens, that is a published case, the courts did allow a combination, even with no reference between the two, to find that there was sufficient evidence to identify an officer in a case. Nixon allowed, I believe the first one identified just the officer generally as a law enforcement officer. The second identified his agency. And they said in combination, both counts, quote, taken together provide sufficient evidence to ID and locate that officer. So in the past, the courts have in fact done that combination. It's on the same indictment. Malice is listed in the arson, and it's clear from anyone, including the defendant, that those two are the same act, that there was a fire and that the dog died within the fire. And those elements should be taken into consideration together. Based on that, and thank you, Judge, for allowing me overtime, we would just ask that you would affirm these convictions. Thank you so much.
Thank you.
Thank you.
Ms. Blythe.
Your Honors, just briefly, the state did raise the issue of the case in Weber as one of the sort of failure to act cases, and I did want to take this moment to clarify that what the court said in Weber was that the question wasn't whether the defendant knew he wasn't feeding his dogs. It was whether he knew they were suffering. And that's where we got intent and malice. And it's important clarification on the level of knowledge one needs to have. In addition, I did notice that the state made the point that assault is different than discharging a firearm into an occupied property. And I do understand why, but I do want to point out that the discharge of a firearm into an occupied property is actually in the assaults section of the statutes, and that is because it is for the protection of people. The state also pointed out that, also discussed this issue of, can you sort of put in facts in place of an element? And I want to be really clear that there is some conflation here of the issue of, did you have an essential element in your indictment, and did you have concise factual statements to back up that element? And so when we talk about Russell and Nickens, let me grab my page here. In Nickens, that the state discussed, the essential element of both crimes on the indictment was a public officer. In both counts, the state alleged the essential element explicitly, a public officer. What the court was talking about was the details of the concise factual statement that backed that up. There's never been an indication that you can replace an element with a concise factual statement. And similarly in Russell, that the court did allow some borrowing of a concise factual statement that was a description of a forged check, not an essential element. All the essential elements were there, but only because there was an explicit reference from one count to the other, with the state saying they were going to incorporate it by reference. And further, it is true that a defendant can request a bill of particulars, but again, that's not for an essential element, that's for detailed facts in addition to the essential element. Your Honors, in closing, there is an injustice here. Mr. Charles is convicted of killing an animal that he didn't know existed. The state has turned cruelty to animals from a specific intent crime into a general intent crime, provable using transferred intent in a manner akin to the felony murder statute, which is a very specific crime. Whether the court finds that this is a specific or a general intent crime, knowledge that the dog was in the house is required. I want to be very clear, Your Honors, we do feel very sorry for this animal, but this doesn't rise to the level of a crime. Thank you.
Thank you very much. Thank you, counsel, for your excellent arguments. The case is submitted, and we will be adjourned till the afternoon session.
All rise.